What ratio decidendi, or reasons for deciding, are binding on lower courts when it comes to cases involving multiple judges who hand down separate judgments? Before we can answer this question, it's important that we're all on the same page with the general rules around precedent. A precedent is a principle or rule established in a legal case that becomes authoritative to a court or other tribunal lower in the hierarchy when deciding subsequent cases. What the court is bound by is the ratio decidendi of the higher court decision. And the ratio refers to the reasons for deciding, the reasons for making the decision. And it's only the ratio that creates the precedent, not the obiter, not the other comments made in passing in a judgment. Complexity arises when you're trying to discern what it is that is actually binding as a precedent when you have a case that involves multiple judgments. What happens when you have some judges agreeing and some judges disagreeing on the outcome of a case, or when judges in a case come to the same conclusion but for different reasons? What is it then that becomes the binding ratio on lower courts in these circumstances? What is the precedent in these cases? There are some general rules around this that help you answer these questions. When you have an instance where there's multiple judgments and there's disagreement between the judges on the outcome of a case, and you end up with a majority judgment and a minority or dissenting judgment. In this instance, the majority judgment contains the binding ratio. So this doesn't mean that the minority judgment does not contain legal reasoning, because obviously the judge has reasoned to their conclusion, but it just means that that minority reasoning has not created a binding precedent. Sometimes all of the judges agree on the conclusion, but use different reasoning to arrive at that conclusion. So when you have a collective judgment and then a separate judgment, the ratio will be found in the collective judgment. So when you have two judges agreeing and then the other judge agreeing but for different reasons, it's that first judgment, the majority judgment, that contains the binding ratio. Another circumstance arises when all of the judges agree on the conclusion, but each issues a separate judgment. So you may have three independent judgments. In this instance, the ratio is drawn from the essential areas of agreement. So we're not cobbling together reasoning from judgment A, reasoning from judgment B, reasoning from judgment C. Instead, what we're looking for is that lowest common denominator. What do these judges agree on? Then that would be the ratio of the decision that has that binding force. Another circumstance arises where all of the judges might agree on the conclusion, but issue separate judgments, and then they don't agree in any of their reasons. In this instance, where none of these judges agree on their reasoning, there is no clear ratio. So what this means is that at most, the decision creates a binding precedent only as to the material facts and the conclusion of the decision it resolved. So basically, it means that the precedent value of this decision is confined to cases of similar facts. Hopefully, these examples help you to understand what the ratio decidendi of a case is in multiple judgment cases, and therefore what the precedent value of a case may be when judges may agree or sometimes disagree with conclusions and or reasoning.